Okay, so got a bit of an update now. Read some more of this Herbert Broom book, Constitutional Law, not just a section on the right to petition, but actually his kind of like the sort of a section towards the end of the book that's got a lot about privileges in it, and he does talk about it. It's important to understand the privileges of the members of Parliament and the House of Parliament in order to understand what our privileges are. They talk a lot less about our privileges because they're quite controversial, but he does admit, Broom uses the word jealousy quite a lot, raising the question that, the members might be jealous of the privileges of the public, even though sometimes there wasn't a parliament and they would be screwed without some other kind of privileges as well. But it's actually very, very clear now. I've actually put a complaint in now against Privileges Committee in Parliament, the MPs, because they rejected another petition which really annoyed me. Petition about repealing an act, which is actually concerning Starmer. Yet that's the name of the act, and you can petition about any act. So, it's actually an instrument, not an act, but it's actually about Starmer himself. And then this is, you can't petition about an MP. Well, an MP shouldn't have his name in an act, then, should they? Now, there's a few things to say, and I got quite a lot of screenshots. You'll see there's 57 plus photos there. There's probably about 60 or 70 screenshots, and you can see I've highlighted in blue the parts that are relevant from quite a lot of pages from that book. So, Herbert Broom. So this book, what can I add now that's important? Firstly, the Petitions Committee in Parliament, one of the bases that they reject petitions is on this thing about, it's false or defamatory or whatever. This whole basis around defamatory or offensive or whatever is not actually a true standard, because the whole point in the Parliamentary Papers Act is to protect against any charges which might arise from those things, so therefore you can include those things because you're protected against it, right? So why would they disallow it if there's a special protection for it? Because then you wouldn't need the protection, would you? So it defies the existence of the protection, the point in having it, right? So that's the... So when false or defamatory, they claim that they're rejecting it on. So if you can remove the defamatory, because that's irrelevant. So this false claim basis, right? They're saying that things that you write in your petitions aren't true or might not be the truth, right? Yet in Hansard we've got petitions read out. And some MPs say, this part's erroneous or that part's erroneous. So they just literally make note of it while they're reading it out. But what Broom says about this is actually got some important points, which I was quite interested to read and find out. He claims that, and we'll have to chase up on this, but he claims that unlike a court, when someone gives evidence in Parliament, they're not required to take an oath. So, I don't know about that, but what I do know is that I've seen people give evidence in Parliament in front of committees. For example, you won't see this in the Petitions Committee because they have, the petitioner sometimes is invited in and they sit at the side and they watch the debate and they can't speak. Only the MPs speak. But there are other hearings and sessions where professional witnesses are invited in, or witnesses are invited in to give evidence. It's just a different type of meeting they have. I'll raise the example of Merlin Sheldrake, right? Merlin Sheldrake is like a fungi expert, right? So they had him in there, and he was sat there, and there was a panel of members or ministers, and they were asking him questions, right? I guess that probably they were all ministers, because I'm guessing that, in the Petitions Committee, they're not all necessarily ministers, because, there was Farage, various other MPs, just MPs, right? MPs can attend and have a say in there, right? I'm guessing that the difference is when people are invited in to give evidence, it was ministers. So I am assuming, this is the part that I'm assuming, I don't think that Merlin Sheldrake took an oath. I think they just invited him in and they said, will you come and answer some questions as a professional witness? I might be wrong on that. It might have changed. But according to Herbert Broom, or at least at the time when they wrote the book, if you're called in as a witness in the Houses of Parliament, you don't take an oath. Well, that means that you're not compelled to tell the truth, right? You don't have to tell. If you haven't taken an oath, you don't have to tell the truth, right? So why are the Petitions Committee saying, we're not going to publish these, or we're not going to run these, or let you collect signatures if they're not making anyone take an oath to tell the truth, right? Because you don't have to tell the truth, right? So that's one thing that I think we've got them on. But saying that, Herbert Broom might have kind of been a little bit wrong. The thing with the oath is it's particularly, well, when you take an oath in a courtroom, you're not taking an oath of supremacy, right? So you're not pledging allegiance, right? But you don't take that in a court anyway. So you don't have, MPs take the oath of supremacy, but members of the public don't have to take it, not even in a courtroom, right? Or you have to take an oath to tell the truth. Your oath is to tell the truth, but the thing about the oath in the court is that usually, unless you're of a different religion, you swear by God, right? Now, the thing is, if you're petitioning the king, right, the king's writ properly, if you petition the king properly, or either Houses of Parliament, you start it off with Charles III by the grace of God, right? So I'm not sure if you are actually, because you're petitioning the monarch by the grace of God, I'm not sure if that's equivalent to taking an oath or not when you put it in writing, like a statement, a valid legal statement. I'm not sure when you sign your name to it that you're signing it that it's the truth. If it is, then the Petitions Committee have got to accept it as the truth. But the thing is, when they run the Petitions Committee e-petitions, it's a different format and it doesn't have the traditional wording to it. You're just writing, pretty simply what you're asking for. And that, according to Erskine May, and that Parliament use Erskine May's book, right, on their website, that would actually be an invalid petition because it doesn't conform to the requirements are that it's got to be in the traditional form, right? So, the Petitions Committee e-petitions have shot themselves in the foot, really, because when they come up with this new format which doesn't follow the traditional form, it's not really a valid petition if they're going by what Erskine May says and they use his book themselves on their website. But they've, quietly took that part away because that also happens to be the same section which says that petitioning is privileged as well, which they don't really want you to know about, right? Now, you're not necessarily saying on oath that you're telling the truth, but at least you're kind of putting it, if you're petitioning the king, Charles III by the grace of God, you're kind of sort of, and when you sign your name to it, it's debatable and arguable whether or not you're putting it some kind of oath to it, or if it's just the King's writ, because they actually refer to it as the King's writ, which means it's a process of the King. You're using a lawful process in law. You're going about doing something in the proper way, lawfully, right? Which is why you're privileged, because you get to use a process with agency, right? Now, it might not necessarily be the truth, but in law for courts, if you give a false statement, that's illegal. Now, the thing is, though, in Hansard, it says, and I've also got this, I've posted this on the page somewhere, it's actually included, that petitioner can't be punished even if they lie or commit a fraud. But Erskine May says it's a breach of the privileges of Parliament, but he doesn't say whether it's a breach of the right to petition, because you can't be prosecuted or punished, right? So, because there's sort of two privileges in a way. And he says you can't be punished for fraud. Now, if they don't require you to explicitly or specifically take an oath, okay, and even people who are called in as witnesses, there's absolutely no... The thing is, the Petitions Committee cannot... if they don't require anyone to take an oath, then no one has to tell the truth, right? And when you're doing the e-petitions website, rather than them sort of, use the traditional format, which is preset, and then you fill it in, they've actually gone the other way and gone even more modern and less official, right? So, I mean, they could actually put a statement on the bottom and you have to tick it, right? They do this when you fill your name and address in, right? When you write your name and you fill your postcode in and your email address, right? So your name, email address and postcode, right? And then you just click on it and say, these are my details, and then it sends you an email and you confirm the email is your email. So you're confirming your identity. What you're actually doing is you're actually saying that this is my identity. So with e-petitions, you actually do confirm that it's you. Now, that's something that you actually are doing in the petition. When you fill the petition in and write it and sign it out, what you're actually writing is that when you do the King's writ, if you sign it and say, this is me, and the humble petition of so-and-so from so-and-so, right? Hold on. Achoo. So you're actually saying that this is, you're actually making, you're signing, when you sign it and your statement, you're saying that this is me, right? So in a way, you are saying that it's you, okay? Now, I think Herbert Broom might have known that when he knows about writing petitions, but maybe he only meant in relation to other witnesses, other persons who haven't written a petition out who are called in, like to give another statement, like Merlin Sheldrake or whatever, who just called in, as a person that MPs might want to, a professional or whatever, whatever information they want to find out, whoever they want to have in there, right? So I don't know whether Merlin Sheldrake did take an oath or not. If he didn't, then who's to say, how do they know whether he's telling the truth or not when he says something? Well, but that's why they've called him in, because he's a professional, but they don't know whether he's telling the truth or not. And who is, this is the thing, right? So in a court, if Merlin Sheldrake was called in to give evidence, he would have to go up and swear an oath, right? That in court, just because someone's professional doesn't mean they're going to tell the truth, right? You can have the top 50 scientists in the world in court, but if they don't swear an oath, then, just because they're the most knowledgeable people on the planet doesn't mean to say they're not going to tell the truth or not, right? So you could have, Merlin Sheldrake and an army of scientists in Parliament. We're going to get the real information now because they're experts, right? But if they haven't taken an oath, the experts don't have to tell the truth, right? So And this is the issue with COVID, you know, because they wanted in the scientists who were going to say things that they wanted them to say. And this is the whole Dominic Cummings and Boris Johnson and all these other, Matt Hancock and all these other people and all this COVID lockdown business when, you know, certain, like we got professionals like Dr. John Campbell, and Parliament only wanted their scientists in and the ones who were saying the things they wanted them to say, and then everyone else was even actually, you know, other doctors couldn't be critiqued, couldn't actually, YouTube were taking videos down from other professional opinions, which is now what Robert F. Kennedy Jr. is saying, that, you know, we're going to follow science, but also have free speech to debate it. So, when they're rejecting petitions on this basis of, you know, it's not true, well, how do they know it's true or not? And how do they know the information that they're looking at and comparing it to? And that's true if no one is to take an oath. You know, and this is the thing, you know, even if Parliament ministers or MPs are sat in the petitions committee, well, how do they know that it's true or not? Well, they have a search where they're going to search, right? Or we'll search the scientific paper. It's only peer-reviewed. The scientific paper is only peer-reviewed, right? And if you submit a peer-reviewed paper to the court, okay, it's peer-reviewed paper, but only, you know, judgment of the peers, peer-reviewed in academic peers. Unless you invite those in and to take an oath, you know, the word peer-reviewed says it all, really, you know. The petition's peer-reviewed when everyone signs it, you know, but it's peer-reviewed of the Commons, but that's why it's the House of Commons. If it was, you know, it's not Oxford University, right? It's not Oxford University. It's not the House of Lords. It's the House of Commons, right? The Commons people, it's peer-reviewed by common folk, right? And if they want the law making so shrimps are illegal to eat, right, it doesn't matter what Oxford thinks. It doesn't matter if Oxford advise against eating shrimps or not. It doesn't matter if Oxford say shrimps are endangered. It doesn't really matter what Oxford thinks, because if 30 million English people want to make eating shrimps illegal, then they'll compel the government to make that the law, right? Regardless of what Oxford thinks. It's peer-reviewed petition of the common folk because they want it. And what you're reviewing is their opinion on whether they want to make shrimps illegal or not whether or not it's good for the planet or whether or not they're endangered, right? You know, that's for scientists to know, and even if the scientists do admit that, you know, peer-reviewed scientists can be outvoted by the public, by the Commons. The Commons people can outvote the peer. Put it this way, when you go to elect your MP, right, it don't matter whether you've got, you know, 2 scientists in the ward or 20,000 scientists in the ward, right? Because when you go and vote, everyone's vote is equal, regardless of whether you're a scientist or not, right? It's common. So this is the thing that Parliament don't understand. So, you know, so there's that thing there. That's important. So apparently, and we need to check up on this. This is why I'm saying check up on it. According to Broome, at least in mid-1800s, no witnesses were required to take oaths when they give evidence or documents in Parliament, right? So that's important, you know. So why should, you know, if they don't require us to take an oath, then they're surely not requiring us to swear that it's the truth, you know. But yet they're sat there deciding on what they want to think's true or not when they haven't even required us to take an oath. Because if they require you to take an oath, then, you know, you've sworn that it's the truth. And at the end of the day, you know, even if it's a, you know, false, you know, statement or prayers are personal anyway. You know, if they want to hold you in contempt of Parliament, but you can't be prosecuted for petitioning apparently, or even giving false information on petitions, according to Hansard. So that's one thing. And that part of it is sort of kind of to do with our rights. There's a distinction between our rights and Parliament's rights, and this is the main thing really, which I've learned from reading this section of the book, right? Which is that so the Houses of Parliament used to be kind of like one chamber, okay? They had like all the peers and the Commons in there together until they made it into two chambers, right? Now, even though like it's privileges of Parliament, there's the privileges of the House of Commons, okay? And there's the privileges of the House of Lords. Now, the House of Lords aren't meant to get involved or decide on matters of privileges of the Commons, okay? And the Commons don't get involved with privileges of the Lords, even though it's in Parliament, right? Which means that the House of Lords cannot decide matters of privileges of the House of Commons. It's their own privilege to decide their own matters, including the seats of their members, actually, which it also notes and says in there as well in this book, even though that in 1868 they made a law so the courts may hear election petitions, but it's still a privilege of the House to be able to debate the seats of its own members, right? Now, so the House of Lords, right, do not get involved with decisions on the privileges of the House of Commons, and the House of Commons don't get involved in the debate in the privileges of the House of Lords, right? Now, what Broome says is that also we've got the subjects' rights, okay, which is the right to petition, and that is another privilege, okay? And what Broome says is that also, this is set in law as well, although there's legislation for the privileges of the House of Commons because they've got acts. They've got the Privileges Act, right? So there is law for it. There is an act for it, a legislation from it. Like, you know, it's actually codified in an act of law. So, but what Broome says, basically, is saying that, like, our privileges, the right to petition, is the right of the subject to petition the king and all prosecutions for doing so are illegal, right? That is our privilege, right? It's actually a privilege of the subjects, okay? Now, you're only going to be using that privilege if you are petitioning either of those Houses of Parliament or the king, but when you do, it's our privilege of the subjects, okay? And it is a privilege, that's important, and therefore, in Broome's opinion, just like the Lords have got their privilege and the House of Commons isn't supposed to get, involved, they're the judges of their own privilege, and the House of Commons, and also us, right? So there's three parties, the three bodies, each with their own distinct privilege, okay? And they're the judges of their own privilege. Now, that means that the court isn't a judge of our privilege because all prosecutions are illegal, right? The court can't be a judge of our privileges because all prosecutions against us are illegal and orders are commitment. So the court is not allowed to be a judge of our privilege, okay? Just like the court can't be a judge of the privilege of the House of Commons or the House of Lords, right? But also, the House of Commons can't be a judge of the privilege of the House of Lords, but also the House of Commons can't be the judge of our privilege, okay? Right? Because we're the judges of our privilege. So, but this is the thing that Broome actually sets out, okay? And that is that, so the Parliament itself is supreme or is superior, right? Because Parliament can make legislation, but the House of Commons can't do it by itself, okay? The House of Commons can't make law, because the House of Commons can only make law when it puts it through into the House of Lords. And the House of Lords can't make law by itself because it's got to get approved by the House of Commons, right? And the House of Commons can't do anything without the subjects because we elect the MPs, right? And we also send in petitions of things that we want them to debate, or go into the surgery and ask them what we want to debate, right? The people who have elected them, right? You know, and even if you say, well, what about political parties? You know, people voted for a political party. What if they don't have a petitions committee? What if they don't even have petitions? Well, we've got a right to petition. They can't take that away. You might say, well, what if it's just like the Labour Party headquarters or the Labour Party members? Well, the thing with the Labour Party members is they're still voters and they're still members of the public, right? They're not MPs. So the MPs can't have a political party if no one joins it, right? Unless it's just the MPs themselves. And if you want to say, well, the Labour Party is just Labour MPs, well, how are they going to get elected then? You know? I'd like to see every single Labour MP go stand in their own constituency alone by themselves, right? And then wait up to see who's going to turn up at the polling station and no one turns up, right? So there is no party without voters. If you get all the Labour MPs together in a room and say, how did you get there? Right? They didn't get there with just themselves. They're having their own party, like COVID party, like with Johnson, right? Oh, it's Labour Party headquarters or whatever, or Tufton Street, right? Oh, look, it's Boris Johnson having a Christmas party. Here they are, all together. Here they are. This is the Labour Party. Well, how did you get there? Who voted you all in? Right? Oh, we voted ourselves in. No, you didn't. You're the candidate. Where are the electors, right? So no MP going to Parliament without the subjects, right? Regardless of what party they support or no party. So this is how Broome puts it, is that none of the independent components, right, can function without the other components. And this is the thing that Keir Starmer probably can't stand or don't like. So therefore, MPs cannot debate in Parliament unless we elect them and give them material to debate. Because, you know, in councillors are meant to be selfless, so I don't know where councillors get their material from. Expensive, development people who come in and put models of, buildings on the table, right? Where do they get the money from? So... all three together, right, work in a synergy, but each has distinctively their own privileges, which they're the sole judge of. And then we get into publishing, right, because Parliament actually. So I was talking about courts having press bans. Put a press blanket on. They can make special orders, so the newspapers can't report things, right? Well, it's very clear through Broome's book, and if you know about Baron Denman and the whole Hansard case to do with, the publication of Hansard and so forth, that Parliament orders things to be published, right? Parliament orders the publication of something. So it's actually ordering a publisher to put something into print or to make it available to the public or essentially the public. So it's actually, it's making an order with the power. It's ordering it to do it. So, yes, you can order something to be published, right? It has to be. This is like for traffic regulation orders as well, local councils, right? So it exists, right? And this is the thing that the Petitions Committee don't want to, for their own stuff, right? It exists so authorities can make orders to publish something. Now, whether or not we've got the right for this, people used to publish like petitions in the 1600s, way before the Bill of Rights, and before that tumultuous petitioning act, leading up to that. The very early press, people were like knocking out like a full book, like petition to the House of Lords, a redress of whatever, and it's like a book, it's like someone like literally wrote a whole book out of their grievance, right? And it was a book, so it was published, and they must have sent a copy into the House of Lords or whatever. That was before the tumultuous petitioning act. So they were, you publish it, right? And what Denman's saying that no one's ever challenged in court the publication of anything by Parliament or by any petitioners, right? Except, I think, for, when the King did get them in the Court of High Commission or, like, chop their ears off or whatever. But that wasn't the public. They didn't do that. Like the common folk, it wasn't at common law. It was like personally the king himself, for doing things which were against the religion of the nation or whatever. It was all the higher courts. It wasn't like no one ever got put into the local court or whatever, and no one stopped anyone from public. It was because they had published it why they got into trouble, right? Because they had published it, because it was published, because they did print a book, right? Not because no one would publish it or they couldn't get it published. It was just they published it and then they got into trouble, right? Afterwards, because the king didn't like it or whatever. So now this is the thing, right? So we've actually got privilege, and we might be the judges of his own privilege, not the courts. That's why the court can't prosecute us. Well, that is quite a new privilege, really, since 1688 ours, although we did fall under Parliament's privilege. But if there is no Parliament, then everyone's going to be using that privilege, because, there aren't any MPs, because you can still go straight to the King and Council if there's no Parliament. Now, where this gets interesting is that, so the House of Lords also was a court of appeal, the highest appeal, but Gordon Brown messed that up in 2010 with this Constitutional Reform Act, and he got this Supreme Court, and he messed up the constitutional rights, really, because the House of Lords is meant to play a role in the appeals, right? But the main problem at the moment, which I can now clarify, is the Petitions Committee on e-petitions, which is only really in the last, since 2006 or whatever, since Tony Blair, Downing Street, e-petitions website, which is, 2006, 16, oh no, sorry, 2000, 2020, 2006, 7, 8, 9, 10, 20. So it's like, about, 10, 20 years or something, right? It's not long. It's not that long. It's not been going that long, really, at all. So, 19 years, I think. 19 years. 19 years isn't really that long, because it's still relatively new modern technology, right? And in fact, that website, e-petitions website, was quite kind of pixely and sort of like a bit, sort of looked like some kind of Nintendo sort of game or something, even in 2006. There were some of the websites that had better graphics at that time. It's not that long ago, really. Time flies though, but, So, what the problem is that everyone's writing their own petition, right? It's a prayer, it's their evidence, it's their statement, and they're signing it off, right? And if obviously you're signing that it's you who's doing it, you are making a statement. Well, it's a statement. You're making a statement. Now, whether or not it's considered and regarded, that depending how you write it and who you address it to, if it's styled, in the name of the King, by the grace of God, and you sign it, if you're signing that, it's you, you're saying that this is me, that's why you sign it, to say that, to prove the point in putting the signature on is to prove that it's you, right? You're required to put your signature on to authenticate yourself. Now, authenticate is an important word here, right? Because you're authenticating it, therefore that you're proving it. Therefore, when you sign your name, you're testifying that it is you who is making the statement, right? That it's not someone else. So that's a form of truth that you're testifying to, right? And also you're addressing it to, whether it's the House of Commons assembled or the House of Lords or the King, right? Now, if you're petitioning the King's writ, you usually go by the grace of God. Now, the thing is, this is an important thing as well. So, if you're just a member of the public, right, you aren't automatically on oath, are you? Although when you sign anything, you're meant to be saying that it's you said it, right, or that it's truth or whatever. But this is the thing: when you go into court, you have to go up and swear an oath to tell the truth, right? Now, this is the difference between people who are sworn in and people who aren't, because this is to do with the oath of supremacy and God and oaths, right? Which is that the whole point of being sworn in, in service to the realm and so forth, and to God, blah blah blah, is that you've made an oath permanently, right? This is to do with peers of the realm, knights of the realm, people in service in government, the president, the king, and so forth. So you don't need to, when you sign a document under an authority, you don't need to always put the oaths and so forth on, because it's in your person, right? So when you sign it, when you put the stamp of the office on it and your name, you're sworn into whatever you write is meant to be bona fide, the fact, right? Because now I don't know about going to court. Why, if you're a police chief and you go up and you have to give evidence, I don't know whether you have to bother taking an oath if you're already sworn in or not, right? But I think they do take the oath to tell the truth, but because the person's already sworn in, they don't need to, but they just do it anyway, right? But a non-normal person who's not got allegiance to any king or monarch or God or religion or anything like that has to go up and take an oath, even if it's for another religion or whatever, right? On each occasion. But once they're sworn in, at least for that oath to tell the truth, then they're meant to be right and honourable, whatever to their capacity. Even professional witnesses have to take the oath. This is the thing. This is what I was saying about apparently there aren't any oaths in Parliament, right? So, So the Petitions Committee was formed in 2006, so it's relatively new. Now, this is the thing. There's three distinct, separate things in Parliament, right? There's the subjects, there's the members, the MPs, and then there's the Lords. Now, we'll start with the subjects. So, the preparation of petitions, okay? The preparation of the petition, right? The writing of it, and obviously getting your evidence, right? And collecting the signatures, okay? And obviously advertising it as well, because to get the signatures, you have to make it known to the public, right? So they're all the privileges of the right to petition, right? They're our privileges, okay? They fall under our privileges. The preparation of it and the advertising of it and the collecting the signatures and possibly getting evidence. So that's a distinct set of things, right? Now, Parliament, the members, the MPs and the ministers, right? The privileges of the House of Commons to debate matters. They can call for evidence, documents, witnesses, and so forth. Well, apparently these witnesses don't have to be sworn in. Apparently they have to take an oath, right? That's what I've heard from Herbert Broom, right? Could tell lies. And I don't think they had them sworn in COVID. They just said, oh, we're going to take stuff down from the internet, and we've got our experts called in. But there's experts they called in. Apparently, I don't know if they had to take oaths or not, which, doesn't stand right well for Boris Johnson with his entertaining newspaper column. So they debate, and then they can also vote and put things through, right? And the Speaker puts it through. And then you've got the House of Lords, right, who've got their own privileges. But notice that all these three distinct aspects, the subjects, the members, and the peers, the lords, none of them can function without the others, right? None of them. The Prime Minister can't function by himself, right? The House of Commons can't function without the House of Lords, and the House of Lords can't function without the House of Commons, and the House of Commons can't have any members if we haven't voted them in, right? And if we haven't given them some material, although Labour would like to believe that all the material comes out of, it comes out of the Labour Party headquarters. That's the only place where material, any decent material ever comes from. But and they'd like it to all come from the Labour Party headquarters. But unfortunately, it's our right as well to come up with the subjects. So now this is the problem. There wasn't really a problem until 2006. Although they had the Tumultuous Petitioning Act, which we had to kind of get consent if we wanted to publish things, but then we've got the Bill of Rights, at least protecting us from prosecution, and for our publishing, because in order to collect the signatures, we've got a right to publish as well, okay? But that's not publishing something after it's been debated and put into Parliament. That's in order to try and get it into Parliament, because it needs to be published in order to collect signatures to get it into Parliament, right? So the preparation, the advertising, collecting evidence, or at least enough to substantiate a claim or statement, I'm not saying, we're not asking for a warrant, to enter a laboratory or anything. You get your information from somewhere. Obviously, you've come about some sort of information, or you won't have anything to write. So the advertising preparation and the collecting of the signatures in order, the subjects, plural subjects, the right of the subjects, plural petition. So, and then you hand it in, and obviously the more signatures you've got, the more it compels them to debate it, or the more stronger evidence you've got, either. But the collecting of the signatures is under the rights of the subjects to petition. It's not a privilege of Parliament, right? That's not a privilege of Parliament. It's our privilege, okay? And this is the thing, right? What's happened is that in 2006, Parliament didn't have to create e-petitions, because we've got newspapers, okay? We've got websites, we've got newspapers, we've got private websites, we've got magazines, we've got flyers, pamphlets, right? And all of those were made use out of, and no one questions, if your petition is accurate or is it defamatory or whatever, because it can't be defamatory because you can't be prosecuted, right? This is the thing. Now, when Parliament, or Tony Blair, number 10, came up with this idea, right? Hey, I'll tell you what, we'll do you a favour. We, Parliament, Tony Blair, number 10, right? All you subjects, all you petitioners, this is the modern era. This is like freedom of information. This is like, we're in the year 2000 now. We've got aeroplanes, computers, rocket ships, lasers, McDonald's drive-thrus. It's the future. It's tech. So guess what? All you good citizens, even the ones who didn't vote for Labour, we're going to do you a favour with your money that you pay taxes in, right? We'll do you a big favour. right? I mean, not that you're paying for it and that you haven't voted for us, but, we're doing you a favour, right? We've got a website in behalf of the taxpayer, a website not owned by Tony Blair, not owned by the King, not owned by the House of Commons. It's owned by everyone for the benefit and the profit of all the realm, right? But you entrust it with us. Don't worry, we'll take care of this website in Parliament, okay? And what we'll do is the right of the subjects to prepare, collect signatures and advertise, right, which is their distinctive right, which is separate from the right of the House of Lords, the privileges of the House of Lords and the privileges of the House of Commons, right? Your privileges, we'll invite you onto this website, okay, and we'll do it together, right? We'll get involved in this preparation of petitions business and this advertising petitions. We'll have a bit of that on the big Parliament, big screen. But even though we're doing this big favour for you, we'll help you out. You don't need to go in the newspaper. You don't need to walk around door to door knocking. You don't need to make pamphlets and leaflets and print, right? Because we're doing you a big favour now. But there's just a little tiny catch, right? A little tiny catch. Seeing as though we're doing you a big favour now and providing, with the money you gave us, a website, we're going to, start to have a little bit of say in how these petitions are prepared and what's going to be written on them and whether we put them on there or not, but don't worry, because,